Hi, friends. Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Every now and again, something comes across my desk that is just really pretty funny, and I have to share that with you when I find something like that. Many of you may know the name Steve King. He was a congressman from Iowa, and it seems that he got trolled and steamrolled in Iowa and then cornholed by the Eighth Circuit in St. Louis. It is an interesting case, and it actually has interesting facts on both sides of the case. So I thought I would start this morning with a little brief introduction of the whole concept of copyright trolling. Now, one of the things that having digital media has done has made it much, much easier to take someone's intellectual property, their hard work, a photograph in particular, and use it without them knowing and without them really being able to do very much about it. And of course, tons of people put stuff on social media that they don't copyright and they don't secure the rights to use other people's images. So it's really a bit of a morass when you put your video or your image out there and it becomes a viral image. A lot of times you lose control over that unless you have been smart. And this is a case where somebody has been smart. And let me explain how a copyright troll works. First of all, in this case, we're going to use photographs, but it could be original artwork. You take a topical photograph. Here's one I did. I'm going to call it Donald Trump's contacts. And I mean no disrespect to Donald Trump. This is simply and explicitly just as an example. Now what you see there, of course, is two orange discs, right? Two orange discs that really are not particularly noteworthy. And they're not particularly noteworthy until you put them on top of an image of Donald Trump. And in so doing, you change the character and nature of that photograph. You put a few words on it, like "I can see clearly now," and all of a sudden you have a meme. And memes have obviously become very, very popular in the last couple of years. But now that you've made your meme, before you ever put it out in the world and send it out there to be used to troll liberals or conservatives or Donald Trump or Joe Biden, whatever it is, right? The first thing you do is you make a stop by the Copyright Office in DC, and the Registrar of Copyrights will, for a fee, register your copyright there and theoretically put the world on notice that that image and that creation are yours, and that they are not there to be exploited otherwise. Then the next thing you have to do is just sit back, throw your hands behind your head, relax, and wait for somebody to use it in a commercial venture. Then when somebody does use it in a commercial venture, you send them a ridiculous letter to extort payment. You say something to the effect of, "That's my copyrighted image. Here's the information which shows that it was registered with the Registrar of Copyrights on this date. You are theoretically on notice that this was a copyrighted image. You used it. You are now guilty of infringement, and I demand X thousand dollars." And it's always going to be in excess of $1,000. Basically, you send the demand letter. If there's no payment, then you have the right to sue in federal court for copyright infringement. Now, it's a shakedown, and let me explain why it is a shakedown. The cost to defend a copyright claim greatly exceeds whatever copyright settlement amount they're asking for. And the risk of losing is simply too great. Several years ago, I represented a respiratory care society in a claim made by a notorious copyright troll, one of the licensing entities that licenses images. And the image was of a particular item. I think it was a vaping device. And they claimed that they had been injured to the tune of $3,000. I explained to them that the image had been used in educational purposes, but at the end of the day, the cost to hire lawyers and defend the society, because I was not admitted to the bar in the state where this happened, and I would have had to travel up there to, get admitted and all of that. That would have made it much more expensive for them than to hire a local attorney. And of course, if they'd hired a local attorney, no telling who they would have gotten and how good that attorney would have been. Despite the fact that I felt like they were being ramrodded, I suggested that it might be a good idea to talk to a lawyer and see if they should defend or whether they should settle, and they wound up settling. And it's a little bit like negotiating with Russians, we will bury you! And that's exactly what they say, You don't take, if you lose, you're going to wind up not only paying the amount of money that a jury awards, but you're going to wind up paying, in addition to that, our attorney's fees, and we don't work cheap. These people didn't hire legal aid. They hired somebody who, bills $750 an hour for work in federal court. It can be pretty expensive to wind up on the wrong side of a copyright claim. Now, this is where Steve King comes in. Political memes are all over the place on X and Instagram, and some of them are pretty darn funny. Many of the meme lords, however, don't monetize their memes. But a gal by the name of Lainey Griner did. She knew that she had gold in a photo of her child with his fist balled up and an image like that of him on the beach, and she called it Success Kid. And, it sort of gives off this vibe of, yeah, Well, not only did it become viral, it became a source of income for Lainey, and I assume they would use it to provide a fund for Sam Griner, who is the child, the photogenic kid. He might have enough money coming through this thing to get him through college. And that's because companies like Virgin Mobile, Vitamin Water, Microsoft, and Coca-Cola all used versions of that in their advertisements. So it was making money. And then along came Stephen King. In his unsuccessful bid for Congress, he used the meme in a fundraising campaign, and as typically is the case, the copyright holder made a demand, and this is what resulted. I will let the Eighth Circuit Court of Appeals tell you how this all got started and what all happened. The King for Congress Committee posted a meme, a humorous online image, asking supporters of the congressman to fund our memes. Lainey Griner, the owner of the copyright to the meme's template photo, sued the congressman and the committee for copyright infringement. A jury found the committee, but not the congressman, liable for copyright infringement, awarding Griner $750, which is the statutory minimum. Both parties moved for costs and attorney's fees. The district court granted in part and denied in part costs to both parties, but denied all attorney's fees. The congressman and the committee, collectively, the defendants, appeal. And because they appealed, she took a cross appeal. Having jurisdiction under 28 U.S.C. 1291, this court affirms. Now, this is written by Dwayne Benton, who is a judge that I worked with when I clerked at the Missouri Supreme Court, and his background is in economics. Judge Benton was the director of the Missouri Department of Revenue, and John Ashcroft appointed him to the Missouri Supreme Court, where he served with distinction for several years, and then he was appointed to the United States Court of Appeals for the Eighth Circuit. So you certainly have a fellow Republican here on the bench with regard to Mr. King, but it doesn't really matter. So Lainey Griner took the photo of her then 11-month-old son, Sam, on the beach. That photo went viral, becoming one of the first and most popular internet memes, known as Success Kid, with billions of uses. Now, Judge Benton goes to the trouble of pointing out to us what a meme is, an amusing or interesting item such as a caption, picture, or video, or genre of items that is spread widely online, especially through social media. And that's from Merriam-Webster's dictionary. And there's, of course, the image. In 2012, Greiner registered the copyright in Success Kid template with the United States Copyright Office. Using this copyright, she licensed the template to many companies, as I said before, Virgin Mobile, Vitamin Water, Microsoft, and Coca-Cola. In 2020, the committee posted a version of the meme on its website, Facebook page, and Twitter account, among other places. This version of the meme placed Success Kid in front of the U.S. Capitol, declaring, "Fund our memes." The post asked viewers to please click the link below and throw us a few dollars to make sure the memes keep flowing and the lefties stay triggered. So the link connected users to a donation page. The defendants never sought or received permission to use Success Kid template. And there it is. So Greiner, through her attorney, notified the defendants they'd infringed her copyright. She requested removal of the posts, suggesting a settlement for past unauthorized uses. No settlement was reached. Greiner sued for copyright infringement and a violation of Sam's privacy. Now, at trial, the jury found that neither the congressman nor committee were liable for an invasion of Sam's privacy, which, when you think about it, only makes sense. If you put a meme out there and it's used by 3 or 4 dozen other people, it's really pretty hard to claim that invaded his privacy. If anybody's liable for invading his privacy, it's his mom. But at any rate, that's what the jury, being a common sense jury in Iowa, found. At trial, the congressman was found not to have infringed Greiner's copyright, but the committee had innocently infringed the copyright, and they awarded $750 in damages, the statutory minimum. Both parties sought costs and attorney's fees. The district court denied all attorney's fees, but granted in part and denied in part the motion for costs. The committee appeals the damages, asserting it had an implied license to use and make fair use of the Success Kid template and thus did not offend the copyright. The committee also argues the district court abused its discretion in 2 evidentiary rulings and that the jury should have been instructed it could give less than the statutory minimum for damages. The defendants appeal the denial of attorney's fees and some costs. At trial, the congressman was found not to have infringed Greiner's copyright, but the committee had innocently infringed the copyright, and they awarded $750 in damages, the statutory minimum. Both parties sought costs and attorney's fees. The district court denied all attorney's fees, but granted in part and denied in part the motion for costs. The committee appeals the damages, asserting it had an implied license to use and make fair use of the Success Kid template and thus did not offend the copyright. The committee also argues the district court abused its discretion in 2 evidentiary rulings and that the jury should have been instructed it could give less than the statutory minimum for damages. The defendants appeal the denial of attorney's fees and some costs. Now they drop a footnote there. Let's look at that. The defendants assert that the district court erred in ruling that Sam's invasion of privacy was not preempted. Because the jury found the defendants did not invade his privacy, this claim is moot. In other words, what are you complaining about? You weren't hurt. So the committee raises 2 infringement defenses, that the committee had implied license and that it was fair use. The committee argues it had an implied license to use the Success Kid template. Courts may find a non-exclusive implied license where 1. A person requests the creation of a work, and 2. The creator makes the particular work and delivers it to the person who requested it, and 3. The licensor intends that the license requester copy and distribute the work. Well, judging from the facts that we just read, we know that none of that happened. The district court ruled that the defendants withdrew their implied license defense. At trial, Greiner's counsel said, "I don't see any way that a colorable argument could be made for implied license." The defendants' counsel agreed. "I don't disagree with opposing counsel. I think that's probably right. I think we'll concede that." So if you conceded it at trial, what in the world are you doing asserting it on appeal? You know, there are just a lot of things that trial lawyers, I think, don't understand about the appellate system. So Issues conceded at trial are waived on appeal. That's black letter law. The committee waived the issue. The committee argues it can defend against a claim of copyright infringement because it made fair use of the Success Kid template. Now, fair use is a well-known defense to copyright infringement, but the jury found the defendants did not make fair use of Success Kid. The court reviews mixed questions of law and fact de novo, meaning as if the court had not ruled it below, just makes it as if it were the trial court, while giving deference to the jury's findings of underlying facts. Courts should appropriately defer to the jury's findings of facts, but the ultimate question whether those facts showed a fair use is a legal question for judges to decide de novo. The 4 factors in the Copyright Act define fair use: the purpose and character of the use, including whether its use is of a commercial nature or is for nonprofit educational purposes. Number 2, the nature of the copyrighted work. Number 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And what they mean there is, if you take a paragraph out of War and Peace, that's not copyright infringement. And of course, copyright infringement wouldn't apply to War and Peace anyway because it was written well before the U.S. copyright law ever existed. I think it was actually written before the United States ever existed. But be that as it may, that's an example of why you would look at the amount and substantiality of the portion that was used. And then number 4, the effect of the use upon the potential market for or value of the copyrighted work. The 4 statutory factors may not be treated in isolation one from another. They're all to be explored and the results weighed together in light of the purposes of copyright. The committee argues the first, third, and fourth factors favor a determination that it made fair use of the Success Kid template and concedes the second factor. As for the first factor, the committee argues that its use is like the billions of other uses of the Success Kid template, the creation and dissemination of a meme. In the first factor, the central question is whether the use merely supersedes the objects of the original creation, supplanting the original, or instead adds something new with a further purpose or different character. When an infringing use is a commercial as opposed to non-profit use, the commercial nature of the use, while not dispositive, is to be weighed against the degree to which it has a further purpose or a different character. The more transformative the new work, the less will be the significance of other factors, like commercialism, that may weigh against a finding of fair use. Fair use is not favored when the user stands to profit from the exploitation of copyrighted material without paying the customary price. A use that shrinks the protected market opportunities for the copyrighted work is less justified because it undermines the goal of copyright. Memes used commercially in advertising or fundraising are subject to stricter copyright standards than memes used non-commercially, which are often fair use. The use, for example, of a copyrighted work to advertise a product will be entitled to less indulgence under the first factor of the fair use inquiry. The fair use provision in the first factor in particular requires an analysis of the specific use of the copyrighted work that is alleged to be an infringement. This court weighs commerciality against its transformativeness. As for commerciality, it is undisputed the committee's use was purely commercial. The meme solicited "Fund Our Memes." The committee sought to exploit the copyrighted material for financial gain without paying the customary price. Thus, the use was commercial. As for transformativeness, adding a purpose or character to the original work, there is a dispute. Creating a meme that was not the original purpose when Greiner photographed Sam. However, controlling the commercial use of the meme was the original purpose to copyright the image. The committee, by creating and disseminating a meme, did not add a further purpose or different character to the template. If the original work and secondary use share the same or highly similar purposes and the secondary use is of a commercial nature, the first factor is likely to weigh against fair use, absent some other justification for copying. Transformativeness relates to the justification for the use. Memes are transformative to differing degrees, requiring a case-by-case determination. The committee asserts that memes, including its own, combine a compelling image with a pithy phrase to invoke a response, usually humor. Because the committee's meme was commercial use, a particularly compelling justification is needed. The committee's stated justification is that they were creating and disseminating a meme on social media, as happens millions, if not billions, of times each day. The fact that everyone else is doing it is not a particularly compelling justification, especially considering the vast majority of these uses are non-commercial. So, this is like, if Jimmy jumped off the roof next door, would you jump off the roof next door? Just because everybody else is doing it doesn't mean you should do it. And frankly, this was about as dumb an argument as they could have made. They should have simply admitted that the use was commercial and attacked on the others. Due to the lack of a further purpose, a different character, or compelling justification, and the undisputed commercial use, the first factor weighs in favor of Greiner. As for the third factor, the heart, the most substantial part of the work of the kid's template is the success kid himself, is used in the meme. The third factor weighs in favor of Greiner. And as for the fourth factor, it's difficult to determine what impact the committee's use had on its commerciality. True, Greiner licensed the template to many well-known brands. Licensing requests, however, had decreased before the committee's use, although a reasonable jury could conclude the association with King would drive away some potential licensees. There is no evidence that the committee's meme revitalized the market for licensing the template, and the fourth factor weighs in neither party's favor. Because the fair use test favors heavily Greiner, the jury properly concluded the committee did not make fair use. Defendant raises three other issues: two evidentiary disputes, a challenge to damages instructions, and the issue of costs and fees. The committee asserts the district court abused its discretion by excluding, for lack of relevance, evidence connecting Success Kid with Pepe the Frog, now allowing the testimony of Ben Clark, Sam's entertainment agent. This court reviews evidentiary rulings for clear abuse of discretion, reversing only when improper evidentiary rulings affect the substantial rights. Let's just skip to the end here. They don't find any error in any of the evidentiary issues. They do challenge the jury instructions. They say we should have been entitled to a jury instruction that allowed them to award less than the statutory minimum. The court doesn't agree. Anyway, the jury instruction challenge is waived because they didn't raise it in timely fashion. The defendants assert the district court abused its discretion in not awarding attorney's fees and costs to the defendants, and the court says, why would we award them to you? Because you were not a successful party. It's only award to a prevailing party. You didn't prevail, you don't get fees. As for the congressman, by Copyright Act, the district court in its discretion may award recovery of costs against a prevailing party. A reasonable attorney's fees as part of the cost. The district court, here in its discretion, denied attorney's fees to both parties. The congressman does not allege an abuse of discretion, acknowledging that the district court had no obligation to award him fees or costs. Now, you might wonder why it is that they did not get an award of costs for the plaintiff. And here's the answer to that. The committee seeks attorney's fees because Greiner rejected a pretrial settlement offer that was greater than the jury award and because it made novel legal arguments. So there is a rule that says, Federal Rules of Civil Procedure 68, that if you reject a settlement offer and they put that in the record and you wind up taking less, well, then you don't get a fees and costs award. And unfortunately, that applies as to the plaintiff in the case, but it doesn't mean that correspondingly you get your fees and costs too, because that is discretionary with the judge. It's always discretionary with the judge. So what do we learn from this? Well, first, Congress critters don't always hire the cream of the legal crop. Asserting asinine defenses like implied license when there's absolutely no facts to back that up is not a recipe for success on appeal, especially when you've waived it in the trial court. Gee, who knew? Second, pigs get fat and hogs get slaughtered. The copyright holder here would have gotten more money settling than taking it to trial. They made a settlement offer. It doesn't say how much, but they made the settlement offer and they took less, which means they don't get costs and fees. So how does this shake out for everybody? Now, King's committee is who we can blame for the appeal because they took this up, but fair use like I said before, is a mixed question of fact and law. And, this was big politician versus small time mom. Where's the sympathy of a jury going to lie? They should have known better than not to settle this case at the outset. In the end, King's Group is going to have to pay $750 in damages, and they're going to have to pay their lawyers and their trial expenses and their expert witness fees and all of that for the people that they lined up, and they're going to have to pay for the appellate expenses as well. So this $750 damage award is more like $20,000 to $25,000 by the time all of that's looped in. And the Greiners, well, they'll get their $750, but since they didn't get fees and expenses, they're going to take nothing in the end, and they're probably going to wind up paying their lawyer $3,000 or so for his or her time asserting and defending them on appeal. This is one of those cases that, had the parties not been so pig-headed, would have settled at mediation. But like Forrest Gump said, stupid is as stupid does. That's what I have for you today. Thank you so much for watching. If you have the opportunity today, go out of your way. Do something kind for someone. Open a door, take somebody to lunch. Maybe you stop alongside the road and give that guy holding the sign that says "We'll work for food" $5 and tell him to enjoy lunch at McDonald's. Those kinds of things are the kinds of things that make the world a better place, and I sincerely encourage you to do them. And after you do, come on back here tomorrow, catch me down here at the beach, and we'll talk about something else neat. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.